Hello, everybody. We might as well make a start. I hope you can hear me. If not, please do shout up. So we're going to now deal with the international panel. What in the world is going on? That's what we're going to deal with, but deal with some housekeeping issues first. So we will take you straight up to lunch, and hope you can stay with us until lunch. Promise you we will not run over. After lunch, 2:15, you need to then make your way into the appropriate room for your workshop. Your badge should say which workshop you chose, and the rooms are indicated all over the area, or you can ask Jess at the back. But roughly, workshop 1 is back in here. Workshop 2 is room 10 and 11 on this floor, and workshop 3 is in room 22-23 on this floor. So we will dive in. So my esteemed colleagues from across our international network, we genuinely all know each other. We genuinely work together frequently. We meet regularly. And we do this international panel every year. So we will dive into some of our differences, some of our similarities, and some of the issues that you might be coming across where you're dealing with international processing. So first of all, if I tell you, these are the topics we're going to cover today, and I'll do introductions for locations. So I'm Sarah Tedstone. I'm dealing with the UK. I'm a partner in the London team, and I will introduce each of them as they go along. First of all, I'm going to set them all a challenge, though. We're dealing with these particular issues, but I want them all to give a brief indication of the state of data protection in their area, or their view of data protection, or the issues that are going on, but I'd like them to interpret it in song. First of all, Carlos from Spain.
Hi, Sarah, thank you. Good morning, everyone. Just to be brief, because it has to be a brief introduction. To me, privacy at this time, it would be the Queen hit, the show must go on. Because now there are more artists in the stage. We got artificial AI, we got data act, we got the cybersecurity. That's fine, they're all related, and there's a correlationship with privacy. But there's still a lot of things you have to take care of, which are specifically from the privacy regulation, which we will see from the penalties that I will explain at the very end of my presentation. So I think it should be the show must go on.
Good choice, Carlos. And then Marcin from Poland, our brand new office.
Good morning. So in my case, I would say it has to be Elton John's one of the new songs for the King Lion movie, Never Too Late, because considering of what I'm going to say later on in terms of the implementation in Poland of the NIS2 and all the other acts, I would say that it's never too late. Thank you.
Thank you. Diplomatic choice, I think. And then to Diego, who is dealing with Italy.
Yes. Good morning, everybody. 1964 Eurovision Song Contest. The very first time an Italian singer won the title with, she was 17 years old, a young girl, not a young lady, singing around her difficulties in being engaged in a serious love affair, but she was too young. And the title was Non ho l'età. No, I'm not enough old. Love. Okay, this case was the topic of the recent sanction that the Italian DPA issued against Luca, the San Francisco company behind Replica, and we will have a chance to talk about these later.
Thank you so much. A great explanation. Thank you. Now we'll go to Philipp from Austria for his interpretation in song. He has a good singing voice. I've heard him practicing, so.
Good morning, everyone. Yeah, for Austria, I chose the song Sorry Seems to Be the Hardest Word. Because when it becomes to data breaches, mistakes, the delays and the legislation, simply apologizing is still not our national sport. Yeah, let's take it like that. So when something goes wrong, we often see more excuses than accountability.
Thank you so much. And last but not least, Nathalie, who is from Belgium, but is also going to be covering France for us today.
Yeah, I don't know if you know, but there's been a lot of drama at the Belgian Data Protection Authority with conflict of interest, whistleblowers. And so now we have a new director, we have a new DPA law, and so there's been a lot of reorg. So I chose Don't Stop Me Now from Queens, because I think now the DPA is finally ready. And for France, of course, I decided to pick a French song, which is Non, je ne regrette rien from Edith Piaf, because you know that the CNIL is a very, very powerful DPA, and so no, they have no regrets.
Thank you, that's brilliant. And I know this is my idea, but this has backfired on me spectacularly because it's all right for you guys. I've got my regulator here. So I was spoiled for choice. I was thinking, could I go for DREAM? Things can only get better. I thought that might be a bit of criticism. Or I Predict a Riot by Kaiser Chiefs. But to be a little bit more diplomatic with the esteemed audience that's here, I've gone thinking about, Kirsten was talking about all the regulations that are involved and all the work that needs to be done. I've gone for Under Pressure by Queen and David Bowie, but it seems appropriate. Okay, enough of the nonsense. We're going to pitch straight in then to the first topic, which is NIS2, so cyber security type issues. Kirsten referred to this. I thought that it would be useful. The offices have collaborated to, as Kirsten said, to deal with implementation, which might differ across each of the jurisdictions, and I thought it would be useful to hear it from the horse's mouth. So, Carlos, do you want to talk to us about what's going on in Spain?
Yeah, well, as you see, the map is in yellow, which means that we have a draft of bill not approved yet and not passed by the parliament yet. Basically, the main things that this draft of bill is saying, just to make it short, it's reinforcing the NIS2 regulation on several areas. Some of them is reinforcing some of the specific security measures that must be implemented or actions towards the value chain of the entities that are submitted to NIS2, and also on their obligation for the entities that are under NIS2 to appoint an in-house responsible person or individual, or maybe outsource it, very similar to the DPO in the GDPR. So I think that for CIOs in Europe, and I think in Spain, it's a golden age, because now they're going to be leveraged to the level that they should be recognized some time ago. Some of the things that the bill is introducing is that there will be a specific list of essential and important entities that in Spain will be within the scope of NIS2. And finally, there is a new structure on cybersecurity in Spain. There will be a nationwide body, depending on the presidency of the government, who will be coordinating the several agencies on cybersecurity that will be doing the task in Spain. There will be 3 of them, one of them covering the army or the military, the other one is covering the aerospace, and the third one that will be covering the rest of areas in cybersecurity, with the government one coordinating them all. And the entities will have a contact point within their ministries just to have a proper coordination in the proper implementation of NIS2. So this is more or less the expected framework. Let's see how it turns out when it's finally passed.
Yes, that's right. Thank you, Carlos. So, Marcin, can we deal with the position in Poland then, please?
Yeah, so I would start with saying that it's too optimistic to say that Poland is within the implementation process, or maybe a little bit too optimistic. We've already started, it's a never-ending story. We've already started like more than 1 year ago with the first draft act that would demand the Polish bill on the cybersecurity national system. Now we have draft number 6. So we've already passed like 5 different drafts amending the Polish law on cybersecurity system. And to be honest with you, at the beginning, everybody was saying that in Poland, the implementation of the NIS2 directive would be the most restrictive implementation in the whole EU. But, well, fortunately, this changed, meaning that the last one, the 6th draft, that was like published 3 days ago, which is pretty extensive. It has like 186 pages length, is far less restrictive. So we may say that it's far more relaxed at the moment, that we are not going to be the country that implements it in the most, let's say, restrictive manner. But nevertheless, we already have certain mechanisms that are different than so we go beyond this directive. For example, we have the mechanism saying that there may be, with respect to the critical incident, the Polish authorities will be able to issue the restrictive order, which will be enforceable momentarily. Or the scope of the entities to be covered by the NIS2 directive is enlarged in Poland. For example, the public or administration entities like the universities or even the institutions of public culture or institutions of culture in general would be covered by the NIS2 directive. So we are in the tunnel. There was a light in the tunnel. Now the light is, let's say, there is less light, but at the end of the road, I think that we are going to implement the law by the end of this year.
Thank you so much. Thank you. Maybe not the most restrictive then, but maybe with 6 drafts, you might be the most precise. We will see. Diego, do you want to tell us about your?
Yes, for once, Italy was not last. Not in the directive, actually, we were one of the first. So we experienced some hiccups at the beginning, okay? I have to say that the tone was set by the choice of the chief of the National Cybersecurity Agency, the ACN, who is responsible in Italy for this. There was a top rankings former police officer specializing in investigation and enforcement. And then there is a platoon of highly ranked technicians helping him out. No lawyers, not that many. Actually, as we saw before in the slides, this is very much an IT and security issue. So it starts from there. Having said that, luckily enough, we had a kind of, as I said, bumpy start because Italians tend to do things at the last minute, and that was the same. And in a public speech a few days ago, one of the boys of the ACN said that actually they've been overwhelmed by zillions of notices and, of course, web forms filled duly, but the last afternoon of the last date at the beginning of this NIS2 era. So they are trying to catch up, and they are doing a good job. I will borrow from you the sorry.
Seems to be the host.
And actually, we are a Catholic country, so we have this system of confession and mercy. No, so we say sorry, and you give your mercy. And this, like enough, is going to be the approach. And he publicly said that they've been very slow in enforcing the first year. They understand the issues also they had actually with the platform, especially with our international friends. This is probably the only real black hole of the system, and working with my colleagues here in the UK and elsewhere in the network, I had to support them in their kind of crisis facing the Italian platform limitation that is very much designed for fully Italian players. And probably didn't expect so many international companies, multinational companies with Italian branches, not taking advantage of the one country principle and having probably enough business in Italy and being forced to file, but at the same time probably not being so structured in Italy to know what is the usual way of, let's say, complying with these agencies. And Italy requires a public certified email box that is very well known by the Italians, but not that much by the foreigners. A certified, officially certified signature, not the commercial one, but the specific Italian certified one. They need cellular phones replying to the OTP sent by the Italian system that apparently doesn't work all the time. There are strict deadlines to reply to these messages, emails, and so on. They're lost in space, and sometimes it's very frustrating. So I see some of my colleagues smiling, if not laughing at that. We had very, very bad nights last nights before. The days were usual, but the nights were not taken into account before the deadlines. The authority also extended the term that was end of May to end of July to give more room for compliance. saying that they will give them mercy, as I said before, to the companies that will show a candid approach. So accountability, transparency is the verb, is the word to keep in mind. If they see that, they will be very, very, very forgiving, let's say.
Thank you, Diego. You are forgiven. Thank you. Philipp, would you like to tell us the complexities in Austria?
Yes. Well, a bit more boring than Italy and in our other southern located neighbors. To make it short, yeah, we have a draft of a NIS2 law. It's been around since approximately 1 year. By the former government, it was discussed. It was, I think, common sense that this is totally contradicting the whole directive. Yeah, so it's kind of legislative, yeah, let's call it rubbish. Yeah, sorry. And since then, nothing happened. Yeah, it's completely still stand regarding this too, which is from a legal perspective, a bit of a limbo, yeah, for the Austrian companies. Yeah, what shall we do? There is this directive around, of course, yeah, and so there are two kinds of clients, I would say. Yeah, the one say, hey, there is no national implementation, I have to do nothing. Yeah, and they do nothing. Yeah, and they don't care about anything. And the other ones try to implement the directive based on the directive itself, of course, which is probably a good idea. Clients and our advice is most focus on the personal responsibilities of the top management and all the board accountability, and also try to push the readiness for any incident responses. What is also kind of interesting, at least from my perspective, is that we see many CIOs and IT leaders of client to be actually kind of happy, yeah, that this directive is around, yeah, because it gives them kind of a legal argument or basis, yeah, to claim more budgets for cybersecurity, yeah, and yeah, another last point is, you know, as we don't have the national transposition, we still don't know which authority in Austria will be competent to take care about the NIS2 implementation. And this raises lots of practical questions because we don't know how strict they will be. Will they be like our DPA, yeah, or will it be a totally new authority? So, yeah, in short, everything unclear in Austria.
Thank you so much. And only a local lawyer can call their laws rubbish.
Yeah, again, I'm sorry, it might be rude. Yeah.
Nathalie, thank you. Can you tell us about Belgium and France?
Yes. Well, Belgium is a good student there. So I think we should all take a little bit of time and look at the map and see that Belgium is in green. So this is really amazing, especially because Belgium has a big tradition of being late for transposing directives. So this is quite amazing. And the way to do it was just by basically copy pasting the directive. It's a simplified approach, I think, that they took. So since April of last year, we have the law together with the royal decree. And also the sectoral authorities have been designated. And on top of this, there is also a national website dedicated to NIS2 with a lot of educational information. So I think on this website, they really did their best to provide as much information as they can to help companies understand the scope. So there's also a scope test tool that you can try out, so which is really interesting. So yeah, this is for Belgium. And for France, well, there's not much to say. Unfortunately, they are still discussing the text. So at the National Assembly, at this point, I am not aware of a final date when this would be approved. What I can tell you, though, is that they have picked the accelerated legislative procedure. So there will be just one review per chamber, but I don't know the date.
Thank you so much. I think you can see why we're collaborating about this because it is so complex. This heat map is regularly shared on social media. We keep it up to date, so we can keep you up to date about that. So the UK position then, the NIS2 directive that we're talking about being implemented across Europe became enforceable in October 24. So it's not directly applicable to the UK. But the UK has been updating its cybersecurity framework to align with similar principles. I think it's worthwhile mentioning at this point that there's been a significant increase in ICO enforcement around data breaches and security incidents. And so it emphasises how important this is and that the UK is on track with this. I would say perhaps they're waiting to see and pick the best bits from Europe, but they have talked about aligning with Europe. So there is a cyber security and resilience bill, which is promised this year. In April, the government produced details of the bill, and I'll briefly explain that. And also the government's working on legislation in relation to ransomware. Consultation closed at the beginning of April, and we're told that that's going to complement this bill. I think my mic is going in and out, isn't it? So the bill is aimed at addressing the specific cybersecurity challenges in the UK, but taking an approach similar that's been taken in Europe. The intended scope is to bring more firms into scope as the European legislation does, sort of recognising the increasing reliance on digital services, bringing more businesses into scope, and sectors managed service providers come within the provisions. It's supposed to strengthen the supply chain security and enable regulators to identify what they think are critical suppliers. There's new powers for regulators and enhancement of their oversight, their information gathering powers and cost recovery mechanisms. There'll be risk assessments and processes, we understand, similar to as proposed in Europe. And finally, improved incident reporting. I think this is seen to be quite an important measure, two-stage reporting within 24 hours and then perhaps something updated within 72 hours. The reasoning behind this is the government wants to know what's going on. So wants to know about ransoms, threatened and paid, vulnerabilities as well as incidents, unless they know the full picture, then we can't really deal with it. So there will be some fairly onerous incident reporting potentially. We're told other measures are being considered, but I won't go through those at this point. Okay, and so Carlos, would you like to tell us about issues in Spain?
Well, not specifically here. I'm going to be really brief because on the DSRs in Spain are really not a major issue, thanks to a couple of decisions from the Spanish Data Protection Authority, who realized that this could be used in an abusive way. So we have found some examples that with exemplaries just trying to exercise that, just to push to the to an expedition to find information that they can be used for the lawsuit, etc., etc. So there's a couple of decisions from the Spanish authority who are really allowing the data controllers just to limit the amount of information that can be shared as a result of a data subject access right. So, and also can just be limited to what is the specific situation in the law, so that it is related with the access, the exercise of this access right. So other than that, this is as unlike as in other jurisdictions in Europe that I know, it's not a really a major issue, and it can be handled really in a really not complex way.
Thank you, Carlos. Marcin, would you like to tell us about Poland's position?
So we do have certain decisions being issued by the Polish authorities in terms of this access right. Those are very old and very boring, and I'm not going to tell you about them. But there is one dated on the 2022, which is, let's say, far more recent one, because the previous were from 2018 and 2019. So this new one from 2022, I think it's interesting because the Polish authorities, on the one hand, they confirmed something which is pretty obvious, is that there are two ways you can execute the right. The first way is you can make an extract, like a copy of personal data being processed, and you can give to the claimant the copy. And then the second one is obviously you can give the physical carrier, like on which the personal data is prescribed, is contained. Yes, so there are two ways. But the personal data authorities in Poland, they said that there is a case where you don't have this choice as a controller of personal data. And this case is when there is a recording of personal data. For example, there is a recording of as a telephone conversation between one of the company's employees and the person whose data is being processed, and then the person applies the motion for the access and the copy of data, and then the control doesn't have anymore the discretion to decide whether it excerpts all the personal data from the telephone conversation or it gives the recording of the telephone conversation, for the simple reason that the voice is considered as personal data. So how can you make an excerpt or a copy of a voice? You can't. So basically speaking, you have to give such a person, you don't have anymore this choice, you need to have this process for making the copy of the recording. What you can do, of course, you can, for example, if you want to defend the rights of the employee of the company being also recorded on the recording, what you can do is that you can mute, for example, the voice of the employee of the company, or you can make some other amendments. But then this is the only way you can do. I mean, you have to generate the copy of the recording and give it to the person that claims this right.
Thank you so much. And I think that's really interesting in the context where we're seeing quite a lot of development of transcription services for calls and meetings and Teams and Zoom meetings and things. Thank you, Marcin. Diego, how about in Italy? It's going to be exciting again, isn't it?
I don't know if it's exciting anyway, without going that much in details. What is interesting to be reported is that last February, on the 22nd, the Italian DPA came out with a kind of decalogue, kind of 10 commandments about what to do with respect to DSRs. And this was coming out after the almost 1 year effort together with the EDPB regarding the CF, the Coordinated Enforcement Framework. And they carried out a survey, I think, all over Europe, all over EU, and checking what was going right, what was going wrong, what were the main complaints, of course, from the interested parties' perspective. And they came out with these kind of decalogue. They came out with a 4 or 5 steps, let's say, action plan and how to improve things also internally, because of course they can, of course, focus very much on the outcome, but then they need to help the players, the companies, and setting up properly their system. That goes very much through, of course, a subjective aspect of appointing the right people, making them accountable, reliable, responsible for that in the companies, giving them the right specialized tools, not the generic ones. Genericity is the main issue, the problem. The answers, at least in Italy, that was the outcome of the survey, many times are too vague, not precise, with not enough explanation notes attached to the data that are shared. And so needs also some training in-house, kind of trials and drills to understand what to do, who has to do what in case of request. And sometimes they're just left on papers and not actually practical. They have to be carried out. So this has been a kind of interesting paper from the authority. I know that my clients are trying to follow very, very strictly, and this is where we are.
Thank you so much. And of course, this is relevant if you're doing cross-border processing and you're having DSARs from individuals in different locations across Europe. The differences are significant in some parts, aren't they, Philipp?
Yeah, we have DSARs in Austria. We, as you all might be aware, we in Austria have been long kind of hotspot there for privacy activism. Let's not forget about Max Schrems and his fancy entity, the NOYB Verein. And so it's absolutely no surprise our clients, our Austrian-based clients, are seeing an increasing use of DSARs as an we say this a strategic tool, yeah, especially in employment disputes and mass litigations in, for example, the edtech sector. We see clients see themselves confronted with lots of DSARs. And the biggest challenge for our clients is to assess when is a request manifestly unfounded or excessive. Yeah. And our courts and our DPA is getting more and more claimant friendly. It's not that friendly, like, for example, in Germany, where you even have to fulfill a DSAR in case of any criminal suspects, yeah, which is going much far than we in Austria. And another issue is the volume and the scope of these DSARs in Austria, where we see our clients struggling with extracting the data out of many different systems and cloud-based systems and whatsoever. Imagine Slack, WhatsApp, or for example, any other things. And so it's important to be, from a technical perspective, ready to fulfill these DSARs. And so in that fact, we see DSARs not only as DSARs itself, they are a kind of litigation risk in the meanwhile in Austria.
Thank you so much. Nathalie, how are we doing in Belgium and France?
Well, data subject request, it's still such a hot topic, I think, with so much complexity and discussion we have with our clients to help them understand the scope. On the website of the Belgian Data Protection Authority, you won't find much around this. There's a bit of guidance for data subjects, but not for controllers. So no templates, no guidance. But there was an interesting decision in January of this year about the DPA gave a reprimand to an employer for not providing, for refusing basically to provide a copy of the ex-employee data. So this decision is interesting because it shows that as a company, if you fail to answer properly to a data subject request, this might lead to bigger problems and to the DPA actually being interested in your GDPR compliance framework as a whole. So this is what happened in this case, because this company refused to provide a copy. And the DPA said that actually the company should do a balancing of interest and cannot actually refuse to provide the data just on the ground that the requester cannot prove that he has a specific need. Okay, so this is quite obvious for us, but this wasn't for this company, who said that, well, you don't need this data, so I won't provide it to you. So bad idea, of course. And the DPA in this decision also confirmed basically what we already knew, is that you need to do this proportionality test on a case-by-case basis. So for each document, before deciding you won't provide it, you need to assess the interest of the data subject versus the other person, including the company. And you should do this assessment on a case-by-case basis. And this means basically that you need to keep all your proof and be able to demonstrate that you have done this assessment. So it's quite a big work. But the decision is also confirming that as a controller, you can decide to not provide the full text, that you could provide extracts or summaries. This could also be acceptable on a case-by-case basis if you have done this assessment. So again, a lot of work for controllers, but an interesting decision, I think. On the CNIL, so on the French side, on the website, you will find guidelines for data subject and also guidelines for controllers, but you won't find templates for controllers. The template letters are for data subjects, obviously. But as always, the CNIL has done, I think, a great educational work by providing very clear guidelines for data controllers. So they have on their website really a step-by-step methodology for controllers on how to understand the request, process the request, and provide the answer. So I think that's interesting. And they also have a specific report on the CNIL's website with all the decisions that are around this topic. So that's also interesting.
Thank you so much. I'm not going to deal in detail with the UK position. I'm going to flog our DSAR event, Data Subject Access event, which we're doing on the 10th of July. If anyone is having issues or wants to know about the up-to-date position, do come along then. But broadly, there are differences, and sometimes I think it can catch clients out. For example, in the UK, we have a stop the clock concept, which doesn't apply across all of Europe. So if you're used to dealing with them in the UK, you may be used to the concept of being able to stop time while things are verified or clarified or fees are paid. And that doesn't necessarily happen across Europe. That's a common pitfall that catches people out. The other difference is we still largely produce copies of documentation in the UK. Application of exemptions is different from European jurisdictions, the way that the number of exemptions and the way they're applied. Just briefly mention the data use and access bill, which has been mentioned before. We're waiting for it any moment. There were some proposals to potentially radically change data subject access requests, but it looks like they've been toned down, and largely the changes are just reformalising things that have been in the ICO guidance, like the fact that you only need to undertake reasonable and proportionate searches and the stop the clock provisions that I mentioned. Okay, so we'll go on to our last topic, and I'm hoping that there will be time for questions. So this might be the exciting bit: the fines, enforcement, and data reform. Carlos.
Well, thank you, Sarah. So, and from Spain now, I will be mentioning 4 things. One is guidance, and then 3 fines that I think it's worth mentioning, because as I said in the beginning, when I was saying that the show must go on, is they're very specific with privacy obligations. So on the guidelines, this year, the Data Protection Authority published guidelines on synthetic data. But basically what they have done, there is a cooperation with the Data Protection Authority from Singapore that already published that. And they have taken this and published it for the Spanish market, which is, it appears it's going to be quite useful. It will complement the guidance that the Spanish Data Protection Authority already published some years ago on anonymization. But now with these advice and guidance for the production of synthetic data, that will be very useful, especially for the artificial intelligence environment and all these, these training and development processes that will require, if you want to skip privacy in those stages of development, using synthetic data will be really useful. So I think it is really a very good guidance that it has been brought to the markets and operators in the artificial intelligence market in Spain. So that's the positive thing. In terms of fines, I will highlight 3 of them that have been imposed so far during 2025, and they're quite relevant. One of them is it was imposed to an insurance company, Generali. Basically, what happened to them is that they had a problem. They had a security breach with one of the client forms that they had online. Basically, it had a security breach that would allow third parties just to access to information. During the investigation, it was also found out that there were some problems in security with their brokers, that they could access to old clients, and lost clients' information that they shouldn't have access to. In the meantime, the Spanish Data Protection Authority confirmed that the company hadn't done a risk analysis on the processing of client data. They didn't have a prior impact assessment. So overall, the Spanish Data Protection Authority imposed several fines on breach on data privacy by design and default, on the lack of security measures, etc., etc. So the total outcome was a fine of €5 million. But they only had to pay 4 because they benefit from early payment. In Spain, if you don't challenge the decision and you go to early payment, you get a 20% discount if you want to. So that's what happened with Generali. The second one, it applied to ING Bank, the subsidiary in Spain. And this is related with consent, because what ING in Spain was doing before the fine was imposed, they were forcing clients to accept that their identity and some of their details were confirmed via checking with the Social Security Service. And they couldn't escape from that. I mean, the clients, or they had to accept that, or they couldn't just hire the services from ING. So clearly, there was not a freely given consent. The bank was saying that they were doing this for money laundering purposes, and they had to comply with the law. But the Spanish Data Protection Authority said, look, I mean, the convention that exists with the Social Security requires a valid consent, or you have to give an alternative. You have to comply on anti-money laundering. If the client is refusing just the data to be checked with Social Security, you have to establish another process, another checking ways to skip that refusal from the clients, which they didn't. So again, the fine was for improper non-valid consent. The fine was 2 million, but again, it went down to 1.6 because again, they went for early payment and they didn't challenge the decision. Final one, and the third one, which is directly related with security measures. It's related with Orange, the telco operator in European, but also operating in Spain, obviously. And it was for SIM swapping. What happened is that they didn't have enough security measures internally, so some of their staff could access to the information to old clients and the information in the SIM cards of clients. So some of them, they had the opportunity just to take it and use it unlawfully, just to to pretend to be still a valid client and get bank transfers, unlawful bank transfers, etc., etc. So again, there was a fine imposed on a lack of proper security measures. This was 1.2 million euro. There was no early payment here. They have challenged the decision and they're still fighting against it. So as I said, I mean, just to summarize, there's some useful guidance, but again, I mean, the show must go on because there's still some important things specifically in privacy that have to be taken care of still while we're having all these new artists in the stage.
This is to your theme. Thank you, Carlos. Marcin, what's your highlights?
So in Poland, we do have the new personal data protection authorities, a new Kłodo, president of the Office of Personal Data Protection, so-called. He has been elected already more than 1 year ago. And once elected, he had been very busy in terms of the generating the standpoints, the official interpretations, the guidelines. So we do have certain guidelines, very precise guidelines relating to the administration of the personal data breaches and the management of the personal data breaches. We have the guidelines relating to personal data protection in the process of recruitment and employment. We have the one issued with respect to the personal data impact assessment analysis. So it's very busy, I would say, but in terms of the decisions, of course, we have very many penalties being imposed, but those will not impress you in any way because the Polish penalties are not very high in terms of the other EU penalties, but there is one, which is, I think, very interesting. This is a very, very recent one, and this one is relating to the presidential elections in Poland. We had in 2020, we had presidential elections in Poland, and at the same time, we had COVID, as you know. So there was this outburst of COVID. So the Polish government had to decide what to do, how to arrange, how to process the elections of the new president, and they were really much wanted to do so. So they found an idea. The idea was that they will instruct the Polish Minister of Digitalization, will instruct the Polish national postage operator, Poczta Polska, to carry on and proceed with the elections by way of arranging for the envelope elections. So the elections based on the envelopes and the letters that you would contain in the envelope and send back to the Polish Postal Office. Now they had this brilliant idea, is that they will excerpt, without the legal basis, they will excerpt all the data from the largest Polish database of PESEL with the names of 30 million Polish citizens, the names, the surnames, the PESEL numbers, and the address, obviously. They would excerpt those, and then they would instruct Poczta Polska to take those from them and to process them by way of organizing the elections. Now, the elections did not take place, but Poczta Polska had been processing such personal data of 30 million Polish citizens without the legal basis, because the act, we were supposed to have the bill but the bill it hasn't been yet implemented. So there was no legal basis. So they said, okay, let's say if there is no legal basis, we can always say that we have F, yes, legitimate interest of the controller, which is the most abused provision in Poland, maybe not only in Poland. If you don't know the legal basis, you always go with Article 6.1 letter F, legitimate interest, yes? So this is the landmark case where the Polish personal data protection said that everything basically went horribly wrong in terms of personal data protection, because there was no legal basis for the Polish Post Office to process personal data. There was no legal basis for the Ministry of Digitalization to transfer such personal data to the Polish Postal Office. There was no information duty being executed with respect to 30 million Polish citizens. And last but not least, the data were extracted and put on the DVDs. They were not even password protected. They were not encrypted. 30 million Polish citizens, they were just put on the DVDs as passed over to Poczta Polska. So we have the highest penalty ever imposed in Poland, which is not impressive to you, 6.3 million euros. This is the penalty being imposed on Poczta Polska. And we have another penalty being imposed on the Minister of Digitalization, which is the highest possible penalty, which is 100,000 Polish zlotys. So it's like, okay, 25,000 euros. But it is a landmark case, meaning that it's the worst possible case that you can imagine that happened.
Thank you so much. That's really interesting. Thank you. Diego, what's the best bits? What's been going on?
Some beauty there, yeah. Okay, but we also do remember that we're dire times, and probably having been so unlucky to have the election in that period was complicated to deal with. Anyway, there's not an excuse for the Polish system, but anyway, in Italy we are kind of carrying out a kind of Italian job. We're trying to steal from Ireland and from Germany the stage and the scene with respect to the GDPR media coverage. Say overall, I mean, of course, Ireland is famous for the highest fines. Germany for the strict orthodox interpretation of the law. And Italy, of course, after the OpenAI case almost 2 years ago, came into, of course, the European scene, being the more proactive with respect to AI and the kind of transparency, accountability in the nurturing the algorithms and training the algorithms. And this is still the case. Probably you heard that since last December, just to name a few, there have been a few other sanctions against OpenAI, DeepSeek, I mentioned Replica before, and they've been already sanctioned a few times, and it's kind of a recurrent thing now. Now they're going after the TV and broadcasting companies. They just fined Sky Italy, that is equivalent to the Sky UK, for mistreating the consumer data. They issued the processing block to DeepSeek. 15 million against OpenAI for lack of transparency and model training and minors data treatment. And Luca, I mentioned before, the San Francisco company with Replica, that is a kind of counseling, psych support, romance chatbot, and they have been fined after 2.5 years almost of inquiries, investigation, replies, stop and go. So the Italian DPA is very active, especially against big techs, AI, see more than on the traditional, I would say, businesses.
Thank you so much. Philipp, could I ask you for literally your best bits? I would like to leave some time for questions afterwards.
Yes, in general, I would say our DPA is not very aggressive. Yeah, we don't see many big fines in terms of EU standards. Our highest fine so far has been also against the Österreichische Post, the National Post Service, because they collected the data of all their customers, which is probably every Austrian from 0 to 100. And They assessed our political election behavior and party and political attitudes, income, and so ever, and sold this data to third parties. And for that, they got 16 millions, which is quite cheap, I would say, yeah, from a data trading perspective. We see our DPA is very strict when it comes to employee monitoring and CCTV. Yeah, there we see the most of the our fines, which is a bit different to other countries, I would say. Last thing to consider, our DPA is relatively small and they have limited resources. And that might also be a reason why they are not that aggressive as they probably would like to be. Yeah.
So much. Thank you. Nathalie, can you tell us the most interesting bits from Belgium?
Yes, in Belgium, there's a tradition of very, very, very small fines. So like or reprimands, a lot of reprimands, a lot of very small fines. We don't have big fines. But now the DPA has a new law with a simplified process, and it will be implemented so very soon. So there will be maybe a change in the way it works. We had a bunch of interesting decisions though. One called Media House, and here it was a penalty payment concerning that the cookie banners and that dark patterns. So pushing users to push on accept all buttons. So that was one interesting decision. The other one is IAB Europe decision, IAB Europe, and it's about TC string, which the Court of Market confirmed that it's personal data. So the TC string combined with cookies is actually linked to the IP address. And so this is considered personal data. So we've been waiting for this decision for quite a long time. For France, I want to flag on a hot topic a new law around telephone marketing, which will now require consent. So that's interesting to know as of the 1st of January of next year. There was also an interesting decision with a big fine against So Local. And this is around conducting a marketing campaign targeting consumers with no consent. So that was also with a big fine, 900,000 euro.
Wow, thank you so much. The UK position then, you're going to hear from the ICO this afternoon, so I'm not going to deal with ICO guidance, and I'm going to summarise so we can perhaps get a question in, but we have the Data Use and Access Bill, quite a lot of secondary legislation needed under that bill, but quite interesting provisions about potentially huge data sharing, particularly in the NHS health space. Our NHS data is hugely attractive. We have significant amounts of data about lots of people going back a long time, so it was always going to be attractive. We'll see. But standardise, to begin with, standardised systems to enable better sharing within the UK of that data. Also, PECA, bringing the PECA fines more in line with GDPR fines. Marketing has traditionally been a big area for enforcement, so it'd be interesting to see what sort of fines might happen there. As I said, huge increase in enforcement in relation to data breaches. So I'll just mention two enforcement actions. One was a £3 million fine against a processor by the ICO, which I thought was interesting. Security failings, a data breach, and involving health data of significant numbers, I think nearly 80,000 people. So not surprising, but interesting that it's against the processor in that context. And we also had a suspended prison sentence for a motor insurance worker who unlawfully accessed personal data in relation to their work.